Good evening, everyone. We welcome you to yet another legal discussion on divorce and judicial separation, Case 7 of Law is Light of the Pro Bono Committee of the Law Students Association of Sri Lanka. We are honored to have with us today two distinguished legal practitioners, Ms. Jerusha Krased Tambaya and Ms. Safna Gul Begum, as our speakers for today's discussion. Ms. Jerusha Krased Tambaya is a well-experienced legal practitioner who has a great deal of experience in the field of tort law, family law, business law, constitutional law, human rights law, commercial law, and labor law. She's a legal advisor to the mayor of the Colombo Municipal Council and has been a part of many high-level legal and constitutional teams, arbitrations, and dispute resolutions. Also, she's an experienced legal academic who serves as a lecturer at CFPS Law School and for Greenwich University program. Also, we have with us today Ms. Safna Gul Begum, who is an attorney at law, a member of the committee chaired by Justice Dr. Salim Marsu, a presidential counsel appointed by the then Honorable Minister of Justice Milinda Moragoda on Muslim personal law reforms, and also a member of the committee chaired by Shabri Halim Dean, attorney at law appointed by the Honorable Minister of Justice Ali Sabri, a presidential counsel on Muslim law reforms. It's a pleasure to also have you, madam, with us today. We are streaming live on Facebook, so you can send us your questions and they will be answered by our speakers at the end of this discussion.
Thank you, Shalomi. Law is Light is a project to educate the general public on the laws in Sri Lanka by simplifying the legal jargon. For better understanding, we started off with the trilingual discussions, but due to logistical reasons, we are compelled to have the discussions only in English. However, in order to fulfill our objective, the organizing committee has taken the initiative to write articles in all three languages, which will be carried on print media to reach a wider audience. Dear viewers, if you prefer a different language, I urge you to stay tuned to our Facebook page, where the articles will be published. If you wish to refer to previous episodes, you can have a look at our YouTube channel as well. Moving on to today's discussion, thank you very much, Ms. Jerusha and Ms. Safana, for being here with us today. Back in the day, divorce was considered demonic, but today we see that changing around the world. However, in Sri Lanka, there's still a negative connotation to the word due to the closed mindset that is prevalent in society. There are many reasons that lead to divorce, but the essence of it, to correct me if I'm wrong, is a lack of compatibility in many forms. But the law in our country has given us the opportunity to remove yourself from a bond you no longer wish to be stuck in. Before we delve into the laws and regulations on divorce, could we address the stigma attached to the word divorce that is prevalent in our country? Personally, I think the very first step in a divorce is a decision an individual makes to say, I'm getting a divorce, or I'm breaking free from this toxic relationship. Ms. Jerusha and Ms. Safana, based on your experience in the field, could you enlighten our viewers on overcoming that stigma and to take the decision to make their life a better life? We have many viewers out of Colombo as well. If we could speak a few words on this, it can help them step out of their negative mindset. If you could start with Ms. Jerusha and then Ms. Safana.
Sure. I think stigma, as you asked, Zeenath, is one of the biggest things here. I think it's a lot to do with a lot of people who come to us for cases, and Ms. Safana will agree. They have children and they worry if their children will be okay, will they be treated equally in society, will they do okay? What's sad is not only the community, but even lawyers have this kind of notion. And they tell, it is masked in the way that they want reconciliation and they support reconciliation. Not that any of us don't, none of us want to break marriages, but when people come forward, it's because it's taken quite a while. It's not the first time something happens that they run to a court of law. So having this stigma doesn't help you, especially if the client is a woman. being known as a divorcee, having to raise her children in that kind of thing. In certain communities where it's religiously also seen as a wrong move, there is a lot of stigma attached to it. We see that people are getting away from it now. It's becoming more and more common. And things are much better now. They should be treated like any other person. It is a contract. You willingly enter into it. You should be allowed to get out of it. And now with the vast number of divorces being filed and also maybe awareness created, it has gotten a lot better. But I can't say that it's still perfect because, like I said, even within the system, a lot of people advocate that people stay in marriages and put up with things, and they stigmatize you based on a lot of things. So this is also one of them, and we still see it. I would say that I don't think women should focus too much about what another person thinks, because at the end of the day, it is you who has to face your home situation, and sometimes it is just a line between being beaten to death and setting yourself free. So I am not a very big believer of these stigma-based guidelines that go along with it. As much as I would support marriage and buttress marriage in any given chance, at its best, it's a really great partnership, and it's a support system, and it's somebody to share your ups and downs with. But at its worst, it is very, very similar to an abuser and a victim, or even sometimes a murderer and the victim, because we see that intimate partner violence is one of the highest rates of female murders in this country. So yeah, it still prevails. We've come a long way. We have a long way to go. And I hope yours generation take it further and make sure that there is nothing attached to it, and it's a simple decision to exit a contract.
Thank you, Miss Safana.
Yes, good evening, everybody. So I must say that is divorce is a very sad thing and pathetic thing. But anyway, at certain point, we can't help it, because either husband or wife, I don't think that they are willing to separate or divorce, because at the end of their dispute only, they are coming to the point, okay, that is, we can't go beyond that, so we are going to divorce. So anyway, at this point, we must say that the children of the divorced parents or separated parents position is also very pathetic. But anyway, according to the laws and reliefs, we have to help them.
Thank you, Miss. Now let's move on to the questions. Start with Ms. Jerusha. Under the general law, can you explain what a divorce is and the grounds on which divorces can be filed in Sri Lanka?
Okay. So in Sri Lanka, under the Marriage Registration Ordinance, that is our general law, a divorce is seen as a dissolution of marriage, which is contracted into by a man and a woman by a competent court. So it is a dissolution pronounced by a competent court of a contract that has been willingly entered into by a man and a woman. According to our general laws, we have three basic grounds that you can go on.
Recording in progress.
The first one is adultery. That is one of the grounds, and that is seen as a very hard grounds to prove, because the burden lies then with the plaintiff to show that there has been sexual intercourse. And in extramarital affairs, as you would all know, it's not done in open. So that's a very high bar to prove. You can name the other party if there is enough proof to show that there was some kind of relationship. And in Gunasekara versus Gunasekara, we see that you can even ask for damages as an innocent party of this particular adulterous three-way. Two people are having an adulterous affair. You are the innocent spouse. You can ask for some kind of compensation under Gunasekara and Gunasekara. So that is the first grounds, that's adultery. It is cited sometimes, but generally along with another grounds, because like I said, it has a heavy burden to prove sexual intercourse. The second grounds I would explain is incurable impotency, which is more a medical sort of situation where your impotency is incurable. It is not about whether you can have children or not. It is only about whether you can have perform sexually or not. And it cannot be something that is curable. You have to be able to show that you have taken steps medically and that you're unable to perform sexually. And if so, if it is incurable, and if the other party, generally the wife, didn't know of this at the time of marriage, this also forms a grounds for divorce. The third grounds is more the popular grounds that is used more often, is known as malicious desertion. It is basically leaving the consortium of marriage without just cause. It is one person leaving. We see two ways which this grounds is applied. Number one, it is where the direct way where a man or a woman leaves the home, leaves the marriage with no intention to come back. That is seen as malicious desertion. And on proof of that, you are able to gain your divorce. The other way, the flip way, is where not the wrongdoing partner, but the other partner or the person who files the case is forced to leave the home because they are unable to live with this behavior or this cruelty or this intolerable behavior, and they leave the home. That is seen as constructive malicious desertion, where because of the other party's behavior, you leave the home, you're forced to leave the home, and you use that as a grounds to gain a divorce. We see that verbal evidence is one of the strongest forms of evidence in malicious desertion and constructive malicious desertion. And this third arm is the one mostly litigated under.
Miss, if I may ask a follow-up question, when you say desertion, like the viewers might be a bit confused because are we saying this person left the house and, for example, like had another house in the next lane and like just left your house, the house you're living in? Or does it mean leave the country? And also, like if two people are in the same house but living separately, like having two gas cookers, cooking separately, does that also amount to desertion?
That's a good question. Actually, the English law defines it much more clearly. Our laws, we see it in case law, that it necessarily doesn't have to be two roofs. It just has to be that the meeting of the minds and hearts have now stopped, where you don't function as a consortium or a couple, you function as individuals. So it can be in the same house in two different rooms, it can be in the adjoining lane, it can be overseas, wherever, but the marriage ceases to exist and one person has left the marriage. On a lot of occasions, we see that when we file to court, the plaintiff files to court, one person has actually left the home. But there have been instances where even in the same house, they were able to prove malicious desertion because they no longer function as a couple and they function as two individuals.
Thank you, Miss. Miss, moving to the second question. Is divorce possible by mutual consent by both parties?
Yeah, I think that's a very good question because there is a belief in the Sri Lankan public. A lot of people who come to us ask us about this mutual consent. Even though internationally there is written law for it, we don't still have written law. It was proposed in the Matrimonial Causes Act, which is still at a bill stage. In 2007, there was a commission put forward, and there it was allowed for mutual consent divorces, but that has still not been passed. As of now, under written law, under the general ordinance, we do not have a right for mutual consent. We only have a way of finishing things off in a faster method. It's called a non-contested divorce, where one party files once you have agreed that you no longer want to be together, and the other person says, okay, we won't contest it. You file a plaint in court, and the other person comes and says, you file a very simple plaint without too much allegations, generally coming under something like malicious desertion. And the other person says, we are not contesting it. And on the first day of trial, certain simple questions are asked and you receive your temporary divorce. That is the fastest method we have, the method closest to what we know as mutual consent. But in paper, in writing, we don't have a mutual consent where both parties can agree. Ours is still a contested system. We don't have a no-fault system. But our personal laws, which seem to be progressive in that regard, both in the MMDA, we have the Mubarak law, which Safana will explain more clearly, which is sort of like a consensual divorce. And under the KMDA, under the Canadian law too, we have this mutual consent based grounds. So, but in the general ordinance, we don't have such a thing.
Miss, why do you think that the difference is? Because, I mean, if there was no law at all on mutual consent, one can conclude on the assumption that it's a cultural thing. But having a personal law, two personal laws that have mutual consent as a ground for divorce, why isn't the general law accommodating it?
This is an excellent question. It is because the the personal laws are based on our culture, and our culture in a certain format was quite progressive in the sense that they don't want to trap someone in a relationship anymore. They are happy to let you go. While as the general marriage ordinance is actually based on British principles, and the English law is based on the Bible, and the Bible, there is a area that believes that divorce is hated by God. So they came off the view that we mustn't release people from this kind of commitment too easily, and we don't want something like mutual consent, then everybody will be running to sort of change things. And that is the basis that the English law started off its older laws. Now even the English law has progressed and they have mutual consent. While as we are still following the Victorian era laws, which are kind of very backward compared to some of the personal laws. I mean, people take a lot of attacks on personal laws, but our personal laws seem to, in some areas, be extremely modern. So this is one of the places where we are following the old Victorian rules.
Thank you for the explanation, Miss. Miss, what is yeah, you mentioned the most common ground for divorce. Is there a reason for the most common ground being malicious decision?
I think when you look at it, I mean, there is no data as such, but if you look at it, I think it's because adultery is hard to prove and impotence is not a very common occurrence. Malicious desertion is based on behavior, which is generally the most common factor for people going their separate ways. And it's also sometimes you're able to do it without contesting and in a simple manner. That is why probably malicious desertion and constructive malicious desertion stand to be the most popular format, because the other two either have a high bar for proof or are not common. So that is why because it's about behavior, most cases come within the scope of this grounds.
And Miss, you said proving adultery is very difficult. So if somebody wants to, if that is the only ground that's available for divorce and this person cannot prove it, and this person wants to get out of that divorce, what can this individual do?
If they have filed only based on adultery and they don't prove, because the standard is beyond reasonable doubt, the law thinks of adultery as a serious accusation. So even in the British cases of Serio versus Serio, even in the Sri Lankan cases, you have to show beyond reasonable doubt that there was some kind of adultery. Necessarily might not have to be explicit videos of sexual intercourse, but something enough to show that there was a special relationship. You can't just show people sitting in a place or walking around or something as simple as that you may do with a friend. So that is why this bar is very, very high. What was your, sorry, yeah. Your exact
but if
question
you have, but if you have a third person as a witness saying that your husband was with another woman, is that sufficient evidence?
Yeah, but what they want to know is that there was a sexual relationship. So that's why it has to be a little more than seeing a person with another person. So it is a beyond reasonable grounds kind of beyond reasonable doubt kind of standard of proof, which is high. And if you have only prayed for adultery and you're unable to prove, then court can technically hold that you cannot be released from this. But if you have prayed both for adultery and for malicious desertion, you can show both. And thereby, even if you can't prove adultery beyond reasonable doubt, you can definitely prove your case on malicious desertion on most occasions.
Okay, thank you, Miss. Miss, our viewers will be interested in knowing how to file a divorce. Can you walk us through the procedure of the application for a divorce?
Sure. So the application for a divorce is called a plaint. You meet with your lawyer. That's your first document, your most important document. That is something filed by the party who wants to seek a divorce from court. It is a document that states your general story. A lawyer will be able to help you draft it. That is the most vital document. And along with that, attaching proof of anything that you may have at that point. Mainly things like your marriage certificate, your children's birth certificate, and other police complaints, other proof that you may on prima facie want to show. You will file this document called a plaint. The plaintiff will file this plaint. That is the application needed for a divorce.
What happens after you file a divorce?
So if you are talking about the process, once you file a divorce, then the defendant, the other party, has an opportunity to file an answer. unless they are filing a document called no contest, where under the law they say, I won't contest it, I want to finish it off very simply. On that situation, court will accept it and fix for trial directly. If they are contesting, they will file an answer. After the answer, the plaintiff is allowed to file another response called a replication. After the replication, both parties go to what is called or get to what is called a pre-trial stage, where they file their list of witnesses and list of documents, and where they settle things called, it's a legality called issues and admissions. That's a legal part of it. It's a pre-trial. It's the preemptive part. It's the lead up to the main trial. Once the pre-trial is over, the trial starts, and the plaintiff can give evidence, be cross-examined. Thereafter, the plaintiff's legal team will put forward other evidences, other people to support the plaintiff's case. Once the plaintiff finishes, the defendant will do the same. Thereafter, they may opt for written submissions, and thereafter you go to where you have the judgment of whether the temporary divorce first, and 3 months later you get your final divorce.
Miss, is this trial a closed trial, or is this will there be an audience? Because I think the viewers might want to know.
Yeah, it is an open, generally in camera, where you get things called up in the chamber of the judge, has to do with if the child is a minor, things like that. If it was a rape case of a minor, things like that, generally judges will consider calling it within closed doors. But where it is your documents are all filed in a public manner, and where it is two adults contesting a divorce, is generally held in open courts.
Now, Miss, I think the viewers might be a bit reluctant having heard this. It's in public, so that they might feel embarrassed. So maybe a word of encouragement for them at this moment, if they're going through.
Yeah, so public in the sense that we don't get people off the street, or not like that. It is only litigants who are there for their other cases. But also at the same time, the court can't stop anyone, because it's a public space, from coming and listening to cases. Now with Corona, it's different. But before the COVID situation, you can come and listen to cases. There was no prohibition. But what you need to remember is that you are in front giving evidence to the record, with your lawyer assisting you. The other people are almost blacked out at that moment. You don't really care, because you're only looking at the judge, you're looking forward, you're looking at the record, and your thing is done, and you are generally there to speak the truth. So whoever is there or not there is not a point of issue generally. And like I said, it's not a crowded space, but it's also not a closed space.
Thank you, Miss. Miss, will parties get compensation after the divorce?
Yeah. So what we ask for or pray for as alimony is generally seen as compensation for a divorce. That means the party who has been wronged is proving their case and saying, for living with you for so many years, and now you have wronged me matrimonially, I want this alimony. Aside from that, there is maintenance orders that can be received, financial orders can be received, property transfer orders, where even properties will be conveyanced to your name. All of that is things that you can receive as an order from a court. But generally, alimony, we don't use the word compensation because it's a personal relationship, but alimony is seen to cover the losses that you have suffered.
Is this gender neutral? Like, can a man also claim these?
Of course. Maintenance laws are gender neutral. Anybody who earns more can't allow the other person to be destitute. Alimony is the same. If you can show the other person, one person has a need, the other person is capable of paying it, and there is rationale in your case for the other person to pay it, any gender will be subject to payment.
Thank you, Miss. Miss, do we have the concept of a prenup in Sri Lanka?
Yes, just before I go to that, just to also tell you, alimony is awarded at the time of the judgment. Say that you apply to court, and during your case, you find it very difficult to support yourself, because it is, say, your husband who's been paying all the bills, and now when you come to court, he has refused to pay. There is something called alimony pendenti lite, which is pending litigation. If you can show your need, again, you can show that the defendant can pay, and court is satisfied, they will ask for payments, maybe part of the alimony or the full alimony, to be paid during the process itself, so that one party can maintain themselves. sorry to have interrupted. I just want to add that alimony can be asked for pending litigation or can be prayed for and received at the time of judgment.
Can I ask a follow-up question for that?
Of course,
Miss,
yeah.
now since we have a very close society in Sri Lanka, sometimes the female stops working or she doesn't, she's right after maybe like at 19 years old, they get married and then it's just the husband and the family, it's their entire world. So if such an individual wants to file for a divorce and get out of the relationship, in terms of alimony, like is there a set time period the husband has to pay, maintain her, or is it like forever?
So what happens is your maintenance orders are generally paid monthly, annually, things like that. But at the end of the divorce, when they decide on alimony, they try and decide to pay it in a lump sum fashion. So they take into consideration all of the losses, all of the sacrifices made by the party who stopped work, and they try to come up with a reasonable amount. It's generally encouraged that this person, the defendant, pay the alimony at the time of the marriage being closed is what normally happens. But you need to take into consideration that, say the court wants to award something like 10 million, at that very moment, the defendant might not have 10 million. So then we have something called a delayed payment where you will say 5 million is paid now, 5 million is paid later. Practical reasons suggest that sometimes this is also allowed by court and court will record it. And if there is an issue, you can come back into court via motion and say this other 5 million wasn't paid later. I am a big supporter of a clean break and lump sum being paid because you want people to move on and not hover around and create more bitterness. But because of the practicality of a person having this large sum at that point, sometimes it can take place even after the final judgment.
Thank you, Miss. So do we have a concept of prenup in Sri Lanka?
Yes. So we don't have the exact concept that you all know and watching movies. But all contracts are accepted by our laws, the CPC, or any kind of contract that two people have entered into is accepted. So there is no issue if there is a prenup. Court will definitely allow it to be followed and allow it to influence their decisions. But we don't have a very popular sort of, I have not seen it too much in litigation that there are prenups, but if there is, it will definitely influence the outcome because a contract is seen as legal. So if you have contracted into something, courts will look at it and allow it to influence the final outcome.
So this is basically a general contract where you state your terms and conditions for both parties and you'll agree to abide by it.
Correct. I haven't seen in litigation too many referred to as a prenup, but I've seen things that they have agreed to which the court has followed. So my understanding is that even if it is named as a prenup, it is something that will influence court unless one party can show their duress or mistake or the general grounds to show that this contract isn't legal.
Miss, could you give us some examples so that the audience can better understand what these terms can be? That if they want to have a contract, they would know.
Yeah. So generally the idea is if one person has come into the marriage with a lot of wealth or a lot of earning or is coming from a business family, a family owning businesses or inheritances, that particular family may want to protect their assets and stuff away from this marriage. Or if one person is generally an artist or some sort of, so say A enters the marriage with 100 million, for example, B enters the marriage with 1 million. So the rationale here is the person with 100 million doesn't want to share this 100 million just because of this marriage. They want to secure this. So they sign a prenuptial agreement saying at the time of this marriage coming to an end, this 100 million cannot be reflected in your settlement. It will be only monies earned after the marriage. Or only 20 million of this will be reflected. Whatever they think is fit. Those are the kind of terms that go into a prenup in order to safeguard extra family or your own wealth and to only keep a limited amount of common wealth in order for final settlement to be reached in this marriage. Also, certain other things like I think you all would have seen in the golfer Tiger Woods prenup, his wife had a clause saying if he cheats on her, she will get a very high payout, right? So, and that she did. So those are certain things that can go into your agreement as well. I think I remember Donald Trump's wife, Ivana, his first wife, I think she took his favorite yacht as a part of the settlement, right? I think those are more to teach you a lesson than for her to enjoy the yacht. But whatever that both parties can agree to, ranging around the monies that they share and ranging around the assets they share, can be seen as terms as a part of the prenup. Why it's not encouraged? Sorry, why it's not encouraged? No problem. Why it's not encouraged is because people think conservatively. Why are you thinking of the end of the marriage when you're starting the marriage? But if you want to go that way, nothing precludes you from signing an agreement. Go on, Zinat. Sorry.
Absolutely, Miss. Miss, now we have a mix of audience who are viewing us with who fall under personal laws as well. Since you mentioned the contract, if somebody does fall under the personal law, gets married under one of the personal laws, can these people also have a contract as such?
Right. So, Tesavalama and the Tamil citizens of Sri Lanka, they still come within the general ordinance. So, if you take it that way, then these contracts will apply. I have never known the Qazi court to accept these contracts. I think Safana will give us a more detailed view. I know that they try to settle on what you bring to court, but I have never known them to take into consideration a contract. But like I said, most of the personal laws are still governed by contract laws. So if you are freely signed a contract, it can be an influencing factor in their final outcome. But Qazis might take up the view that no, we're not taking any extra documents. We will decide it based on the information put before us. Like I said, Safana will definitely have a more grounded experience on that. Jaffna Tamils and other Tamils a part of the country go under the general marriage ordinance. They can definitely rely on a contract. It is Canadian laws and Muslim laws that may preclude you. It might be an influencing factor, but it might not be a 100% accepted contract.
Thank you, Miss. Thank you for the detailed explanation. Miss, can you explain the rights of the parties during the divorce and after the divorce?
Right. So during a divorce, the rights that a party has is they can ask for spousal maintenance. The other party is bound to maintain you if you are the lesser earner. You can ask for transfer of properties if you are taking care of the children. There can be financial monthly settlement payments. There can be lump sum payments. You can ask for maintenance towards the children if the other party is not paying or securing payments for your children. All of this can be done during the divorce process as well. At the end of a divorce, the main things that will be decided as a final order are things like custody. Who gets legal rights? Who gets physical rights? Legal rights is generally the right to sign on major documents and make major decisions. Physical custody is who has the child living with them. So those things will be decided at the end of a marriage based on the best interest principle. They look at what is the best for the child, what is the status quo, who is the primary carer, and accordingly custody will be looked at. At the end of the divorce, you also stand to get your alimony. Alimony will be decided on, and your final payments will be decided on. Generally, after a divorce, everything else ceases because what they're trying to do is release these people from this consortium. So they don't like to have these rights going on and on. But like I said, payments, if they cannot be fully paid at the time of the judgment, you can ask for a delayed payment. And custody is something that is there forever, and you can come for a variation order. So for example, say, so for example, say the mother gets physical custody and the father gets only access once a week. But later on, after the divorce is over, the father finds out that a man with a bad track record is now living at the mother's place. And he finds it very disturbing. He can go to court and vary the ongoing custody order. So that will last even after a divorce proceeding. Maintenance for the children. So say your child was getting a certain amount, but at some point your child meets with an accident or I mean, for some bad luck, has an illness. You can come and vary the maintenance order for the child. Those things will leak away or go outside the divorce proceedings. Everything else will be generally decided at the time of divorce and judgment.
Okay, Miss. Miss, what are the legal consequences of a divorce?
Right. So the legal consequences of a divorce, one is the order that you get to do with your custody. The other is your property redistribution. If you have a matrimonial home, will you share half-half? Will it be sold? Will it be written to the woman? All of that is consequences that are done at the time of a divorce. Your financial orders, your alimony, either the full payment, lump sum payment, or your delayed payment, all of that are consequences of a divorce. Otherwise, you'd have never had to pay alimony. Now you have to pay them forward, right? They will look at, now I see a lot of people looking at shares that were bought together, businesses that were run together, lands, investments that were taken together, pension schemes that were entered together. Even future profits are looked at when deciding on your maintenance. All of that will be looked at, and a settlement will be done at the point of divorce. I think, like I said, generally the idea is to settle it in a way that the parties can move on freely. But there are also people who run things together who may want to, I think you all have recently heard in Bill Gates' divorce, they have agreed to run the company together, which means that will still go on aside from everything that you settle in your divorce. So even here, most things will be looked at the time of divorce. But if you're running something together, that can still be severed away from the consequences of finance, property, custody, alimony, inclusive of all the investments that you have together.
But then again, it depends on the maturity of the two individuals, if they can handle a business together, doesn't it?
Yes, I think the break, I have seen even in the most of violent incidents, the break does everyone good. The clean break does everyone good, and people sort of are much better for it after the break. Some people obviously may not heal and it might not do anyone good for them to be in touch. Some people I have seen who come for their divorce cases together as friends. And we do it and they go back together. I have done those as well. So it depends from person to person, as you said.
Miss, can you briefly explain what are the special laws available for divorce in Sri Lanka? Just an overview.
So we have the marriage registration ordinance that I've been talking about all this time. All the provisions I've spoken about, including the 3 grounds like adultery, impotence, and malicious desertion. All of that ranges in the marriage registration ordinance. Aside from that, we have the Canadian Marriage and Divorce Act, the KMDA, which has 6 grounds for divorce, inclusive of this mutual consent grounds, cruelty, incest, etc. Then we have the MMDA, the Muslim Marriage and Divorce Act, which Safana will talk about, which has 4 types of divorces: talaq, fasa, kula, and mubarak. It also has the contested version and the mutual consent versions. And then there is one where one party can make a final decision as well. All of that comes within the MMDA. Aside from that, we have the Tesavalama. It doesn't have a direct connection with divorce laws, but it more has a bearing on property.
Okay.
So those are the different laws.
Miss, in an instance where your spouse is a foreigner, then what law applies?
Are you asking if your spouse is a foreigner, or are you asking if both parties have a foreign marriage registration? Which one are you asking?
One is a foreigner, and the other one maybe if you're a foreign registration.
We both are right. So in all situations, if you're living here, you still come within the jurisdiction of court and you are able to apply for a divorce in this country. The only thing that you need to look at is if your registration of marriage is done in another country, will this divorce that you get in Sri Lanka be applicable under that law? Sometimes domestic laws don't allow for other dissolutions to invalidate a registration. So for example, Sri Lanka doesn't accept divorces taken in foreign countries. So whenever my clients have come back with a divorce certificate, we have to refile and get another divorce in this country in order for you to be a divorcee in Sri Lanka. Some laws accept, some laws don't.
So that is in the instance where they get married in Sri Lanka, go to a foreign country and get a divorce in the foreign country.
Yes.
Right.
They have to come back and get it here. So if we have 2 foreign nationals living here, I'll make it simple so it's easier to understand. If you have 2 foreign nationals living here who are married in another country, Yes, by living here, they come within the jurisdiction, they can apply for divorce. But just because they get a divorce here, it might not invalidate their foreign marriage license. In a situation where they're married here, whether you're foreign or not foreign, you will still come within our law. Anyway, so there is no issue, you can still file for divorce here. So in all circumstances, you can file, but if your registration is from another country, you need to check with your domestic country whether they accept this Sri Lankan divorce. If they don't, you will have to reapply and get a divorce in that country as well. It's under the private international law.
So in essence, a divorce will be valid where the marriage occurred, the country where the marriage occurred.
Definitely, it will be valid where the marriage occurred. Some other countries are willing to accept if the divorce is from a different country. Some countries, their own laws suggest that they can't accept a divorce from another country. Like us, we don't accept. So even if you have got, so say 2 of our people went to Germany, lived there, got a divorce, when they come back, we are not happy with that. We want it reapplied through our system and for us to give a dissolution.
Okay, Miss. Miss, now we'll move on to judicial separation. Could you explain what judicial separation is?
Yes. So judicial separation is generally seen as a halfway between marriage and divorce. It is a grounds that is allowed so that people don't separate or divorce due to the normal stressors of day-to-day life, and that they are given an opportunity to go their separate ways and rethink if they can come back together. That is judicial separation, and that is why it's there. It's guided by a legal system, but it is not seen as a divorce. It is only the right to not cohabit anymore. You are asking for permission to not cohabit with the other person.
What are the grounds for judicial separation, Miss?
Right. So when we look at grounds for judicial separation, there is 2 grounds. One is that the other person has become intolerable to live with or dangerous to live with. And the second grounds is that the other person is acting in an unlawful manner and we shouldn't be allowed to live with them. So things like cruelty, things like someone having an illness like HIV, all of that can come into place to show that you cannot be expected now to cohabit further with this person.
Miss, in an instance, if your spouse is engaged in some illegal activities, for example, say selling narcotics, drugs, so in such an instance, can a divorce be filed, or is it just judicial separation?
I mean, you can opt for both. As a spouse, you know, we have the right to privacy between spouses, so you can't really litigate or give evidence against them. You can choose either. But under judicial separation, the bar for evidence is low. All you're saying is, I cannot be forced to live with this person. It's intolerable. I want 2 years, it's generally given for 2 years, to not cohabit. Nothing else changes. You can't remarry, all of that can't happen, but you are allowed to stop cohabiting for your own safety.
Okay, Miss. Does judicial separation automatically dissolve a marriage after a certain period?
So it's not automatic. After 2 years, court is giving you the option of filing for divorce. That is your option. You can extend your judicial separation, you can go back to your partner, or you can file for divorce. It gives you that option, but after 2 years.
Okay, Miss. Miss, now when a person goes through a divorce, they're called a divorcee. But when what is a person called after a judicial separation? I'm asking for the societal sake of it, because we did have certain discussions going on after the beauty pageant was, so I was wondering if you can clear that up for the audience.
Yeah. Just point of reference, the beauty pageant, there was no judicial separation either. So then I think you're still called a wife, pending whatever result. Judicial separation, I think you will be called a separated person or a judicially separated person. There is no special name. It is to avoid this tag of divorcee, because back in the day, Catholic marriages and certain very conservative Hindu families, they don't like this tag of divorcee. So in England also, we saw a lot of them going for separation, judicial separation, instead of a final divorce. So here too, we have different reasons of cruelty and all of that, but it can be done for stigma as well. They don't want to maybe go for their daughter's wedding as a divorcee. I had at least my senior had a client, and that case went on forever. So we also managed part of it, where this woman for over 8 to 10 years wanted to delay the divorce because she didn't want to be a divorcee at the time of her daughter's marriage. Right? So people like that can opt for this kind of terminology. You will be just known as a person who is judicially separated.
But Miss, it doesn't really matter, right? Whether you're called a divorcee or a separated person, you're still out of the marriage. And
Yes.
like the terminology should not matter.
It should not matter. Yeah. Go on.
But we have this negative stigma towards it. I mean, why is the reason for it? Why do people like insist on, as you said, being called just judicially separated as opposed to just a divorcee?
Right. So I will go into this because I think our society and a lot of Asian societies and even other parts of the world, I'm sure the Western societies, there's a lot of stigma with everything. People just want to judge you for whatever you do. So if you're not divorced, you're doing something wrong. If you're divorced, you're doing something wrong. If you're separate, I'll give you an example. When I had my first baby, and my kind of work, I do a lot of work with women and children. I had to go back to work in about 3-4 weeks because I had some urgent cases while I was feeding. So part of court was like, what are you doing here? You're a horrible mother. You have left your feeding baby and you have come back here. Some of my other friends were like, oh my gosh, are you going to retire now? Are you going to become a housewife? And is this going to be your life? So whatever you do, there will be people calling you out on it. And I think in our more urban cultures, we don't care. But in the more rural cultures, it matters what your tag is, what your name is. If you're a single woman, it's all about protection finally. Because what people think is, she's a divorcee. So maybe I can visit her in the night. Maybe I can do, so that is the kind of protection that they're looking for, which is very unfortunate in this country. Personally, if you ask me, I couldn't care less about names. There are people in marriages who are worse off than divorcees. There are people who are divorced who are probably closer to their ex-spouses. We don't know this. It is not for us to judge unless you're living under somebody's bed. But because of society and how they put this kind of pressure on people, women especially, they are very aware and wary of this tag. It's almost like a bad name. They just want to name you this and lump you as some woman. I think it's looked at as a failed marriage. It's not an exam. It's not a race. It's not something that you can fail at because you're not running it alone. It's a partnership. So there are many reasons partnerships can fail. But society still likes to peg you as a failure. I think that is why there is all of this protection and this reluctance to be tagged under the certain name.
Thank you very much, Miss, for the detailed explanations for all the questions.
No problem.
Miss, please do stay in the Zoom link because we'll go to the next segment and then we'll have the Q&A towards the end.
Sure.
Now we'll move on to the next set of questions. Anjali.
Thanks, Ina. Miss, we'll be moving on to the part where we discuss nullity. So as the first question, I would like to ask you what is nullity of marriage?
Okay, so nullity is generally a declaration sought from court that your marriage was never legal to begin with. It is unlike a divorce where your marriage is accepted as legal, then you have certain issues, then you come within certain grounds and you gain a dissolution. A nullity is saying that your marriage is so legally wrong or defective that it was never legal in the first place. So that is the declaration you're seeking from court, that it never existed legally.
So then what qualifies a marriage to be null and void?
Right. So there are two sets of principles that come about. We have the first set of principles that are in the MRO, the registration ordinance itself. Minimum age. If any of the parties were minimum age, under the age of 18, it will be seen as a null and void marriage. Prohibited decrees, where you marry your relatives, direct relatives, incestual relationships, father, daughter, uncle, in certain cultures, uncles, sisters, siblings, grandparents, and grandchildren. Those marriages are prohibited. So if there has been a marriage within these relationships, it will be seen as a nullity. Then we look at bigamy, where without gaining a divorce from one person, you go on to marry another person legally. So then your second marriage is seen as a nullity. We also look at defects in formalities, where you don't get married in a proper registration place. The marriage is not solemnized by somebody who has the power to solemnize. Where you go under false names to get registered because maybe you're scared of your parents, things like that. All of these will give way. There are grounds to apply to court for a nullity. There is also voidable reasons. What I mentioned now was void reasons. Those are mainly seen in case law. Things like duress, shotgun marriages, where you're forced to marry the person, or where there is incurable impotence. Not only divorce, it is also a grounds for nullity. Or mistake, where there is a mistake as to who you're getting married to. So I don't know, in our day, our favorite cricketer was Kumar Sangakkara, so I will go with that. You think you're getting married to Sangakkara, but you end up marrying somebody who looks like him. That is a mistake. It's grounds for a nullity. I hope he doesn't sue me using his name. Or it could be mistake as to nature of the ceremony. You think you're getting married at a licensed temple, but you get married at a place that doesn't have the authority to license your marriage. These things for mistake also, you can file for nullity. Or there is a grounds called illicit sexual relations, where you are having sexual relations out of your marriage. But unlike adultery, if the marriage was never consummated with the partner, but you are having relations outside the marriage, that is also grounds for nullity. And then we see pregnant by a third party, where say a woman marries a man, 3 months later she gives birth to a baby who is from another man. That is grounds for her current husband to ask for a null and void order. So these are the different grounds that you can come under.
Thank you, Miss. Third question is, are the children in a null and void marriage legitimate?
I mentioned this MCA, this Matrimonial Causes Act that was proposed somewhere around 2007 by a commission who was asked to look into reforms. Under that, they wanted to explicitly in the law state that children are always legitimate. Marriages can be faulty. Children are always legitimate, but unfortunately that act has still not been passed. So in black and white form in written law, we don't have anywhere that says that children from a annulled marriage are legitimate. But in practice now, with DNA tests, blood tests, being able to prove who the father is, being able to gain your maintenance from that father, technically in practicality now, children are seen as legitimate. They can't be legitimate because they are born from A and B. And now you can, by a test, find out who that party is. But in our black and white law, in our written law, we don't have still anywhere that says children are legitimate, unlike the UK laws and other laws that we see, other jurisdictions that say any child is legitimate. We don't have that in writing, but in practice, more or less now, the legitimacy is there.
Okay, Miss. Can you remarry after the declaration of your current marriage as null and void?
Yeah. So a divorce accepts that you are released from a marriage. Nullity states that your marriage never legally happened. So you go back to the place legally of how you were before this happened. So you're a single person and you have every right to marry. It's almost a higher sort of declaration than a divorce, because it's basically saying legally, we don't even recognize you as ever been married before. So you have every right to remarry.
Thank you, Miss. We are moving on to the divorce aspect of personal laws now. So, as you mentioned in Tesavalame law, divorce is governed under the general law, but you said that there are legal consequences in relation to the property rights. Could you please explain a little bit on that?
So when it comes to divorce and divorce grounds, we come directly under the general law. But when it comes to property, we have three aspects: Chidanam, which is dowry, which the woman brings into a marriage; Mudusam, which is either party brings into marriage, like inheritance or any property they bring in at the time of marriage; and then Thirdiyathirtam, which is what both parties jointly earn during the marriage, right? From the 3 itself, you can see the woman is in a weaker wicket because she has to bring in this dowry. It's not a must seen by a man to bring in anything, but the woman has to bring in dowry. Third year, third term, and Mudusam. Mudusam, basically, the woman doesn't have a right to unless expressly written to her at some point. Even third year, third term, there is a understanding of Tesavalama law that normally the lands will be held by the next male heir. So I was reading up on a case which said the husband was so worried for his wife that he wrote her a check for a certain amount of money so that she will have some monies when he dies, because normally the holding of property is done under Tesavalama law, generally more by the male than the female. So there is that distinction, and it is against the equality principle. But in terms of divorce, they come within the 3 grounds afforded by the the MRO.
Thank you, Miss. So this is we are moving on to Kantian law, and these questions are directed at Miss Safana. Miss Safana.
Yes, Anjali. Yes, I'm here.
Yes, Miss Safana. So, can you please explain the grounds for divorce under the Kantian law?
Yes, when we talk about Canadian law, that is the marriages and divorces of Canadian law are governed by the Canadian Marriage and Divorce Act number 44 of 1952. So section 32 of the Canadian Marriage and Divorce Act says about the grounds for divorce. Accordingly, that is number 1, we can say adultery by the wife after marriage. And number 2, adultery by the husband coupled with incest and gross cruelty, and complete and continued desertion by the wife for 2 years, and complete and continued desertion by the husband for 2 years. And the next one, inability to live happily together, of which actual separation from bed and board for a period of 1 year shall be the test. And the last one is mutual consent.
Thank you, Miss. Let's talk about the procedure. So, when it comes to Canadian law, so where do you go to apply for a divorce?
Yeah, that is according to Canadian law. That is we have to file our application to the district registrar. Actually, section 33 says about that. For example, we will say that if anyone wants to file an application for the divorce based on the aforesaid grounds which I explained, except the mutual consent, then the application will have to be filed to the district registrar, to the district where the applicant resides. So suppose we will say if the applicant is not residing within the Canadian province, then the application can be made to the district registrar, to the district where the respondent resides or the marriage was registered. Then if the divorce application is based on the mutual consent, then if either party, that is the application can be made jointly to the district registrar, to the district where either party resides. Then suppose if both parties are not residing within the Canadian province, then the application can be made to the district registrar, where to the district where the marriage was registered. And we can, when we say about the procedure, upon receipt of the application, then the district registrar can fix a date and time for inquiry and issue notice to the parties. And on the date fixed for the inquiry, the district registrar can dispose the matter on summary inquiry. And after that, upon the discretion of the district registrar and satisfaction of the case, either can grant the divorce or refuse to grant the divorce. This is the procedure.
Thank you, Miss. So, do we need a lawyer in this sort of a procedure?
No, we don't have to.
Okay, so you can go by yourself and go through the procedure.
Yes.
Okay, so the documentation process is not the same like in the divorce procedure in the general
Under the
law.
general marriage ordinance, yes.
Okay, thank you, ma'am. So the final question on Canadian law is: let's say a Canadian person married a non-Canadian, so and he wants a divorce. This person wants a divorce. So then, how will that be granted?
Yes, that is, Canadian Marriage and Divorce Act is applicable only the persons who are governed by the Canadian law. So if both parties are governed by the Canadian law, then they can marriage under the Canadian Marriage and Divorce Act. And I have to say here, that is the persons who are governed by Canadian law have option to choose whether they are going to get married under the Canadian Marriage and Divorce Act or General Marriage Registration Ordinance. Suppose if one party is governed by Canadian law and the other party is not governed by the Canadian law, then they cannot get married under the Canadian Marriage and Divorce Act. They have to marry under the General Marriage Registration Ordinance. And if a marriage is contracted under the Canadian Marriage and Divorce Act, then the marriage has to be dissolved only by the Canadian Marriage and Divorce Act only, not by the General Marriage Registration Ordinance. If the marriage is contracted under the General Marriage Registration Ordinance, then that marriage can be dissolved only by the General Marriage Registration Ordinance and not by the Canadian Marriage and Divorce Act.
Thank you, ma'am. So I invite Farah to continue the questions on Muslim law.
Thank you, Anjali. Ms. Safana, my first question is under the Muslim law section. What are the types of divorces available under the Muslim law of Sri Lanka, and the grounds in which divorce can be obtained?
Yes, Farah, that is, before we are talking about the type of the divorce, we have to say that is the Muslims of Sri Lanka. Their marriages, divorces, and connected matters of the Muslims who are inhabitants of Sri Lanka are governed by the Muslim Marriage and Divorce Act number 13 of 1951 as amended. So now we are coming to the types of divorce. For the clear information, that is, we can divide those types of divorce into three. One, we can say a divorce initiated by a husband, that is called as talaq. And number two, it's a divorce initiated by a wife, that is, we can divide into two, that is, one is fasa and the other one is kula. And the third one is a divorce initiated or divorce on mutual consent. Now we will come to the first type of divorce, a divorce initiated by a husband. It is called as talaq. So Section 27 of the Muslim Marriage and Divorce Act is the substantive provision for that, and rules set out in the second schedule is the procedural law for that. So we have to say here, there is no ground for a husband to pronounce talaq on his wife, according to the Muslim Marriage and Divorce Act Sri Lanka. If a husband wants to pronounce talaq on his wife, he can go to the Qazi court, and in the presence of the Qazi and in the presence of two witnesses, that is, a husband can pronounce talaq on his wife. And here we must say, according to the Islamic principles, there are three forms of talaq. One is ahsan form of talaq, and the other one is hasan form of talaq, and the other one is talaqul bidda. So if we take ahsan form of talaq, that is, we can simply say one pronouncement of talaq and 3 reconciliation efforts within 3 months period. If we talk about hasan form of talaq, that is 3 pronouncement of talaq and 3 reconciliation efforts and within 3 months period. That means the first pronouncement will be pronounced at the end of the first month, and the second talaq will be pronounced at the end of the second month, and the third talaq will be pronounced at the end of the third month. Both talaq ahsan and talaq hasan are revocable divorce. When we talk about talaqul bidda, that is like triple talaq, 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 talaq at a time, that is within 1 month, only 1 month reconciliation effort. But here we have to say, according to rules set out in the second schedule of the Muslim Marriage and Divorce Act of Sri Lanka, it defines only ahsan form of talaq, that is 1 pronouncement of talaq and 3 reconciliations efforts within 3 months, which is revocable. Then there is a famous decided case, that is Khan versus Moomin and others. In this case, it was held that according to the rules set out in the second schedule, describes only ahsan form of talaq. So we can say only ahsan form of talaq, which is revocable, is available in Sri Lanka. And now we will come to the second type of divorce, that is a divorce initiated by a wife, that is we can divide as fasa and kula. Now we will talk about fasa. For fasa, that is without the consent of the husband, a wife can obtain fasa, but only thing is, that is she has to have grounds. According to the decided cases, we can divide that fasa also for easy reference into 3. One is grounds based on ill treatment. That ill treatment may be physical ill treatment, verbal ill treatment, or mental ill treatment. And the next one is fault. The fault can be act of omission. For example, non-maintenance and desertion. Third one is non-fault grounds. That is, for example, according to the decided cases, we can say that is inability to maintain and leprosy of the husband, insanity of the husband, and impotency of the husband. When we talk about impotency of the husband, that impotency will have to be commenced before the marriage is contracted and consummated. Then only the wife can obtain the divorce. And when we come to kula divorce, fine, there is no ground for a wife to can get the divorce against a husband. But main thing is the wife will have to get a consent from her husband to get the divorce. And she has to pay compensation also to the husband to get the divorce. And the next type of divorce is divorce on mutual consent. That is if both parties decides, right, okay, we can go for the mutual consent divorce, that is they can go and obtain to the mutual consent divorce. That is a very easy divorce.
Thank you, madam. As you mentioned earlier, talaq is the divorce that is given by the husband. So
Yes.
a follow-up question on that. Should he give reasons as to why he's divorcing the wife?
No, that's what I said. There is no reason will have to be defined by the husband to get a divorce, because the schedule specifically says that is the reason doesn't have to be recorded by the Qazi. Actually saying there are a lot of decided cases says the pronouncement of talaq is an inherent right of a husband. Even the Qazi has no judicial power to decide whether the Qazi can allow a husband to pronounce talaq on his wife or not. Only the Qazi's part is only the mediation part. Only he can see whether there is any possibilities to reconcile on the part of the husband. If there is no reconciliation on the part of the husband, Qazi has to allow the husband to pronounce talaq.
Do you need to give proof of mentioning the word of talaq to the spouse, or is talaq pronounced in front of the Qazi?
Actually saying that is also according to the rules, it says that talaq will have to be pronounced by the husband in the presence of 2 witnesses and the Qazi and comma and wife and within bracket if she is present. So even if she is not present, that is, a husband can pronounce talaq, but if the husband pronounces talaq in the absence of the wife, it is the duty of the qazi to inform the wife that the talaq is pronounced by her husband on her.
Thank you, madam. My next question is, can a person who is married under the MMDA obtain divorce under the general law of Sri Lanka?
My answer is no for that, Farah. And let me explain that. Actually, according to the General Marriage Registration Ordinance as well as Civil Procedure Code, the Muslims who are inhabitants of Sri Lanka are prohibited from marrying under the General Marriage Registration Ordinance. If the parties who are Muslims who are inhabitants of Sri Lanka, they have no optional right like Canadian Marriage and Divorce Act, either to marry under the General Marriage Registration Ordinance or their personal law. If they are Muslims, they can only get married under the Muslim Marriage and Divorce Act only. If one party is Muslim and the other party is non-Muslim, then they cannot get married under the Muslim Marriage and Divorce Act. They have to go under the General Marriage Registration Ordinance only. So if a marriage is contracted under the Muslim Marriage and Divorce Act, then that marriage will have to be dissolved by the Muslim Marriage and Divorce Act only. If the marriage is contracted under the General Marriage Registration Ordinance, in a case one party is non-Muslim and other party is Muslim, then the marriage can be dissolved by the General Marriage Registration Ordinance.
What is the procedure to file a divorce? Is the divorce procedure the same for both the men and women under MMDA, or is it different?
It is a very excellent and fantastic and interesting question. That is, either whatever type of divorce, that divorce will have to be filed to the qazi, to the area where the wife resides. That is, it can be talaq divorce, it can be fasad divorce, it can be kula divorce, or it can be mubarak divorce, to the qazi where the wife resides. As I said earlier, that is, the pronouncement of talaq is an inherent right of a Muslim man. Without any ground, he can obtain the divorce, and the qazi has to allow him to pronounce talaq. Now we will come to the wife's case. Okay, we will say that she is going for fasad divorce. That is, I explained the grounds for fasad divorce. That is, for fasad divorce, that is, she has to prove, according to the rules set out in the 3rd schedule of the Act, she has to prove the grounds, that is, by her evidence on oath or affirmation. And not only her evidence is not sufficient. Her evidence will have to be corroborated with another 2 witnesses' evidence on her behalf to prove the ground for a wife to obtain a fasad divorce against her husband. Then there is kula divorce. That is, when we see briefly, that is a very good thing. That is, there is no ground. Without any ground, a wife can get a divorce by way of kula from her husband. But she has to get a consent from her husband. There is a decided case, Ansar versus Mirza. It says that without the consent of a husband, a Sri Lankan wife who is belonging to Shafi sect cannot get divorce, kula divorce, without her husband's consent. So she has to get the consent from her husband, as well as she has to pay compensation to the husband. So we cannot see there is any balance or equality procedure in divorce procedure under the Muslim Marriage and Divorce Act between men and women.
Thank you, madam. My next question is, can a woman file for divorce if she finds out that her husband has married a second time without her knowledge or consent?
That is, you can go through section 24(1) of the Muslim Marriage and Divorce Act, FARA. That is the duty cast on a husband who is going to enter into a second marriage, and subsequent marriage are defined in that section. Before 30 days of his second marriage or consequent marriage, he has to give the notice to the qazis for the area of his previous wife or wife's resides, and the area where he resides, and the area on which his future wife, he's going to intended to be married, his future wife resides. So that is the only duty for him to do before he enters into the second marriage. And the qazi's duty is also only the administrative duty, not the judicial power. So, as there is no legal requirement for a husband to get a consent from his wife according to the statutory law to enter into second marriage, then how can it be a ground ground as a divorce for a wife?
Just a follow-up question on that. If that is the case, in the meantime, will the qazi inform the wife, or is he obliged to inform the previous wife regarding this?
No, not necessary. What is the qazi's duty is, qazis will have to paste the notices which were handed over by the husband regarding his second and consequent marriages only at the public places. And after 30 days, it is a mandatory duty cast on the qazi to give a consent letter to the husband to enter into second marriage or consecutive marriage.
If I may interrupt, Miss, can a Sri Lankan Muslim woman, prior to getting married, can she bring up a term saying that a husband should not go into a second marriage? In the event he does, that she will file for a divorce. Can that term be introduced before getting married?
Actually, saying Zeenath, that is, there is no specific provision in the Muslim marriage and divorce with regard to that. But there is a type of talaq called talaq-e-tafwid, but that is not practiced in Sri Lanka. The talaq-e-tafwid is actually, that is actually wife is pronouncing talaq on her husband, saying that if there is a condition, suppose for example, as you said, okay, before the marriage, she says, if you got married, if you are going to enter into the second marriage or subsequent marriage without my consent or whatever, then I will get a divorce from you. If she enters into a contract like that, then if the husband violates that terms of the contract, then the wife can get the divorce. That divorce is called talaq-e-tafwid, but that is not in that is not in practice in Sri Lanka.
Thank you, madam. Can a lawyer accompany you to the quasi court on behalf of your divorce case, or should he or her have a lawyer accompany?
No, that is actually, there is a specific provision in the Muslim Marriage and Divorce Act, section 74. It prohibits an attorney at law or lawyer appears in the Qazi court or represent the parties or witnesses in the Qazi court. But in the Board of Qazis, that is, you all will know, that is the appellate forum from the Qazi court. If it is in the Board of Qazis, that is, lawyers can represent the parties or lawyers can appear on behalf of the parties. But in the Qazi court, there is a prohibition for the lawyers to represent the parties.
Does the husband have to maintain the wife after divorce?
That is actually in section 47 1D of the act deals with this, Farah. It says that actually you all know after the divorce there is a 3 months idda period, that is a mourning period. So for that 3 months period after the divorce, the husband has legal obligation and duty to maintain his wife, that is called as idda maintenance. If a wife is pregnant at the time of the divorce, then that husband has legal duty to maintain that wife until she delivers the child. Apart from that, there is no maintenance or other consolatory payment like alimony in the General Marriage Registration Ordinance, not recognized in Muslim Marriage and Divorce Act. But here I must say that under the Islamic principles, there is a consolatory payment entitled to a divorced wife from the husband, which called as mata. But even though, because even in the Qazi courts and Board of Qazis, in certain cases, that is the mata is paid by the husband to the wife. But anyway, as there is no specific provision in the Muslim Marriage and Divorce Act in respect of mata, still it is an challengeable and arguable matter.
Farah, I have a follow-up question on that. Follow-up question, ma'am.
Yes.
So can a party get married within that period you mentioned? One of the parties remarry?
No, actually section 22 says that is that, actually Anjali, what is your question? Which parties, that the particular parties who divorced?
Yes, so
What is your
during
question,
this, so I wanted to know whether the parties who got divorced,
yeah,
who got the divorce, and so they are in in that period, and can either these parties get remarried?
remarried mean one party to another man.
Another,
No,
yes,
that
another.
is for a man. There is no idda period at all. That is, they can have 4 wives at a time according to the Muslim Marriage and Divorce Act. There is no idda period for them. So for the wife only, she is having idda period for 3 months. During that 3 months, according to the law, she cannot get married.
Thank you, ma'am.
My next question is, if a couple is unable to have children, can they seek divorce?
Again, I have to come far from the beginning, I think, for the talaq. That is, if a husband wants to divorce, that is, there is no ground. Even if he is having that ground, without mentioning that ground, he can get the divorce. So if it is a wife, then if she wants to go for fasad divorce, then importance will have to be commenced before the marriage is contracted and consummated. And okay, then wife will go to Kula divorce based on this ground, because suppose there is no ground for Kula divorce, then she has to pay compensation and consent. So particularly based on this ground, that is, a wife cannot get the divorce. But always husband can get the divorce.
When it comes to the children who are born to the couple that is divorced, what happens to the children? What is the process for the maintenance and of the children after a divorce?
Yes, maintenance of children. When we talk about maintenance of children, that is actually if the child is a female child, actually father has sole liability to maintain the children according to the Muslim Marriage and Divorce Act. So if the child is a female child, until the child is get married, this is the duty of the father to maintain the child. So if the child is a male child, until the child started to earn on his own, That is, it is the duty of the father to maintain the child. When we talk about the custody of the children, that is, the Qazi has no jurisdiction at all in respect of custody of children. If the custody matters arisen, then only the district court has jurisdiction in respect of custody matter. So Muslims, we will have to file an application according to the Judicature Act only to the district court in respect of custody matters. As an upper guardian of the children, the district court, as usual, will look into the best interest of the children.
That's all the questions we have for Muslim law. Thank you very much, Madam, for giving us a detailed clarification and explanation on this topic. Now we have the general Q&A session. Over to you, Zenith.
Thank you, Farah. Miss, we have circulated a Google form prior to this discussion, and we encourage the general public to send us their questions on the topic. So we'll go into those questions now. The first question is, Ms. Jerusha, is the act of rape between a judicially separated couple a ground for a sure divorce?
Zena, to answer your question, I think what they're trying to refer to is a marital sort of rape, which we don't have in this country. So that is not a grounds for divorce at all. So even in a form of judicial separation, that cannot be brought in. It at best would be a domestic violence scenario, but it will not be a grounds for divorce.
Okay, Miss. Miss Safana, as I asked Ms. Jerusha at the beginning, regarding the contract where we can have a separate contract and have certain terms and conditions between the husband and wife, is that possible for a Muslim couple, apart from the Muslim laws, to have this as a separate contract under the general law?
General law with respect to matrimonial affairs, you see?
Yes.
No.
And the finances?
No.
Okay.
No.
Okay. Ms. Jerusha, there's another question. Section 22 of the General Marriage Ordinance states that the consent of the father is required to marry, but isn't the legal age for marriage 18 in Sri Lanka?
Yes, the legal age for marriage is 18. There was an older law where between 16 and 18, you can get parental consent, which is not something that's encouraged now. So at 18, you don't have to, under the General Marriage Ordinance, seek any permission. That was an older law that is repealed. Now you can get married after 18 without any permission. There was a allowance for those between 16 and 18, which you will have to get parental consent. But if you're above the age of majority, there is no consent needed.
Okay, thank you, Miss. Miss Safan, you mentioned that a Muslim can marry a non-Muslim. Under what law can that happen?
That is under the general law only, not under the Muslim Marriage and Divorce Act.
Because we did have, like my committee did look through the ordinance, and the preamble stated that the general ordinance excludes Muslims. So
that is one party is Muslim and the other party is not a Muslim.
I'm sorry, I didn't get it. If the ordinance excludes Muslims?
Excludes Muslims. If both parties are Muslims, then only that Muslim Marriage and Divorce Act is applicable. If one party is Muslim and other party is not Muslim, then the Muslim Marriage and Divorce Act is not applicable. And General Marriage Registration Ordinances, if both parties are Muslims, they are not governed. They are not governed by the General Marriage Registration Ordinance.
Okay. Thank you for the clarification. Yes. Ms. Jerusha, do we need to give a notice of marriage before getting married under the general law?
Yes, that is what comes under formality. The notice was given back in the day with the idea of if somebody is married in a different town, moving to a different town, trying to take another wife at the same time, or there is something in his character that you want to find out. It used to be pasted outside the registrar's office. Now they probably have a better method. But yes, notice has to be given so that anyone in the public can say, bring forward reasons as to why they're against this marriage. Is the general understanding. If that doesn't happen, the marriage will go as planned.
Miss, if there's a pending divorce, can that person get married?
Is this for me? Are you
Yes,
asking me?
miss.
Yeah.
Yes.
So pending divorce, a person cannot get married. You cannot even get married under the General Marriage Ordinance and Tesavalama as well if you have only received your temporary divorce, which is known as a nice eye order. Even during that period, you can't get married. It is only after you get your absolute order that you are permitted to marry. Otherwise, it will be seen as bigamy, and bigamy is seen as a criminal offense in Sri Lanka.
Okay, Miss. Miss Safana, now when it comes to consent, there is a debate on the consent in under Muslim law. My question is now, correct me if I'm wrong, the Prophet has said that if two parties, the two individuals concerned in getting married, the man and the woman, if one of them don't consent, the marriage is null and void, according to what the Prophet's teaching. So there is also a consensual aspect in terms of the father of the child. So the father is to sign the marriage contract for that marriage to be valid. So there are two types of consent involved. Can you explain how that is perceived in the Sri Lankan culture and how effective both consent are?
Yeah, that is when we talk about consent, Zenith, that is according to section 25, according to section 25, it says that for the marriage, that is the wali's signature, actually for the marriage certificate, if a people who governs by Shafi sect, you know that Shafi, Hanafi, Hanfali, Maliki, both are all are four schools of thought. So that is if a lady who is governed by the Shafi sect, then that is wali. That is the wali is a marriage guardian. Wali's consent is necessary. It's a mandatory requirement for her to enter into a marriage. And according to the Muslim Marriage and Divorce Act, also when you see the marriage register, that is only. There is a space only for the signature of wali and not the bride. So without wali, she cannot get the marriage. But anyway, that act says that wali has to get the consent of the bride also, but there is no procedure to prove whether the consent of the bride is actually obtained by the wali or not. But if in the case of Hanafi sect, if it is a case of Hanafi sect, the wali's requirement is not necessary. So that if a bride who is under Hanafi sect, she can get married without wali's consent. And she can, on her own, she can sign in the marriage register also. But unfortunately, even there is no space saying that bride signature. But even if a lady who is under Hanafi sect, she used to sign in the marriage register at the space allocated for the wali.
Now, Miss, for example, say this girl gets married after the father signs, right? And there is a marriage contract. And if this girl says that she was forced into the marriage and that her consent was not obtained, her emotional, her personal consent was not obtained. So according to what the Prophet has said, in such an instant, that marriage stands null and void, which means that girl does not have to go for a divorce. There is no marriage that existed. Is that the case in Sri Lanka under the
No, under the Muslim Marriage and Divorce Act. No, it is not like that.
So it doesn't really reflect the Prophet's teachings to the dot.
Yes. There is no specific provision for that.
Okay. Miss, also another question. If a Muslim couple lives together without signing a marriage contract, will it be considered a valid marriage under cohabitation of the general law?
Marriage contract, you mean marriage register?
Yes.
Marriage register. Yes, that is, we can read section 16 of the Muslim Marriage and Divorce Act. It says, validity or invalidity of the marriage are not depending on the registration of the marriage, But even that nikah ceremony, that is the solemnization of the marriage called as nikah ceremony, is sufficient under the Muslim Marriage and Divorce Act of Sri Lanka for a marriage to become as a valid marriage.
Okay, Miss. Thank you, Miss. Anjali, over to you for the rest of the questions.
Thanks, Seerat. So this question is to Ms. Jerusha. What is the ground for divorce that can be used by a victim of domestic violence?
Right. So this is something that I have been propagating personally for reforms in the divorce law, because very unfortunately, cruelty is not seen as a grounds for divorce. You can get your protection order, but it is not a direct grounds for divorce. We see the case of Gomez versus Gomez, where there were years of cruelty, but after the cruelty, the lady went on to live with her husband. The matter was appealed right up to the Supreme Court, and the late Prasanna Jayawardena, including him and two others, they gave a judgment saying they cannot give the divorce because it doesn't come within a three grounds, which meant cruelty is not a standalone area for you to get a divorce. So domestic violence, therefore, cannot lead to an automatic divorce. You will still have to come within the other three. Constructive malicious desertion sort of touches on the fact that you are unable to live with this person, that's why you left. But it's not a direct grounds, and I am propagating very strongly that that be considered a grounds, because cruelty then breaks the entire relationship, the spirit of the relationship. But as of now, it's not a grounds. You can only get your protection order and go within the laws of domestic violence, but not directly apply it to your divorce as a fully fledged grounds.
Thanks, Miss. So the next question is, so this is directly the question the person has asked. I need to know whether I can have a committed relationship with another person while I'm separated from my husband. And under a divorce, will my house and property be shared in half between my husband and I?
There is two questions there, no?
Yes.
Unfortunately, committed relationship is not in the sphere of the law. Whether you can have a relationship with someone else, according to the law, it will still be seen as an adultery if it's pending divorce. So at any stage, if the trial is not over and they decide to bring in witnesses, that will still bear some kind of adversity to the person who is in a relationship before the end of the divorce. So that is the adversity there. The second part of the question is, if you can repeat it, please.
So this person wants to know whether her house and property will be shared in half between husband and.
Right. So I'm reaching out to the UK law or some of the other laws. We have cases to show 40%, 50% of what the consortium has will go to either party. In Sri Lanka, we don't have the 50% sort of rule. Maintenance and divisions are generally more towards the person who has control over them, less towards the other party. So say, for instance, a wife gave up, stayed at home and all of that, she will get something, but it almost never reaches the 50% mark. So that is not a like an automatic principle here.
Thank you, Miss. So the other question is, in a situation of a mutual agreed divorce, at the trial, can either party say they are not okay for it, even though they agreed previously? I think.
Right. So before the trial, when one party has filed the plaint, the other party files a Section 72 document to state that they will not contest it. That technically means that you are consenting and mutually trying to finish this off. But because our laws don't allow for mutual consent, technically at any point you can withdraw that consent and you can say, now I'm not interested. Technically you can do so. But the other party can show the 72 document to show that there was intention. So say for an instance, you file a plaint on the belief that there's going to be mutual consent. So therefore you don't put very heavy or salacious accusations and you stick to a very simple plaint. The other party first says they are not contesting, later withdraws it. You can also withdraw your plaint and put in a full plaint if necessary. That is not disallowed. Before the trial stage, that can be done. Otherwise, at the stage of them filing the document itself, you record that there is no contest and you fix for trial. So technically, yes, you can change your mind. But the other party also has the freedom to file a full plaint and contest it if needed without foregoing their rights. Does that explain it?
Yes, it's very clear. So the last question, so from Facebook is, due to COVID, the divorce trials get postponed, and is there a way to request an urgent hearing before the next trial date given by the courts? Also, any option to get the trial during this period prior the opening of courts?
Right. I'll answer both. Number one, can you get it called up? Yes, we have been doing so. We've had this COVID situation for over a year, and we've had people who wanted to go overseas, who have to different things. So we filed motions, try to get the matters up as early as possible and sort it out. Can these matters be called up during these closures of courts? No. It is with the greatest difficulty that my colleagues and some of us signed documents, sent it to different BSL, Justice Ministry, all of that, and we've gotten permission now to take up urgent domestic violence and maintenance matters during the closure of courts. But it doesn't extend to general divorces. So divorces can't be taken up in these closures prior to the opening. But once it opens, you can definitely file a motion, show urgency, and finish it off. But unfortunately, the reality has been, because of the heavy burden the court has also had to suffer with postponements, that some of my divorces from last year have still been given dates and they're still pending even as of now.
Thank you, ma'am. So
Recording
this
stopped.
question is not directly connected to divorce, but this person has asked, is living together legal in Sri Lanka? And if we have children, are they legitimate?
Recording in progress.
Yeah. So living together, there is nothing to prohibit it. It's not legal in certain cultures, in certain countries. It is treated very much like a de facto relationship. Here in our laws also, if you have lived for several years, sometimes the law looks at it as a de facto relationship. But otherwise, you don't have the rights that a married person will have, in the sense that if you have lived for a few years, you can't go and ask for maintenance or property adjustments and things like that. The child can definitely ask for maintenance, because you can do a simple DNA test, prove that that's the father, and therefore whether the marital status of the parents don't count, the child will anyway be maintained accordingly if they are able to prove the DNA. But in terms of the cohabitees rights, you don't have all the rights that you can seek as a married person under the marriage laws.
Thank you, Farah.
Now we have come to the end of a fruitful session on the topic of divorce and judicial separation. Now I invite my friend Shalomi Dasan to give the vote of thanks.
I'd like to thank our speakers, Ms. Sapna Gul Begum and Ms. Jerusha Prasad Tambaya, who clarified the questions and doubts of the general public by giving us very detailed answers and comprehensive explanations. We express our gratitude for being a part of this discussion that aims to educate the general public. We would like to also thank Nirmal from the Media Committee of the Law Students Association of Sri Lanka, who, for his assistance, technical assistance in streaming this online discussion. Last but not least, we would like to thank our online participants who actively engaged in this discussion by sending us comments and questions. We hope that this discussion paves the way for a thought-provoking discourse on the general public on divorce and judicial separation. Thank you.